The university is broken. Yes? Those of you who work in one know that it's not really a place where people search for truth or can be called a community of scholars. There are pockets, of course, and people, exceptions, and places where the traditional vision of a university is probably valid, but it has also changed. It's petty. It's corrupt, intellectually corrupt. It's a breeding ground now for authoritarians. And the symptom that may be most acutely seen in terms of the transition of the university from something we know to something we don't like is in the area of free speech. Now, I'm sure you all have either know personally or have heard of the events, the stories, the occurrences where a guest speaker is invited in, and then there's a response, or a rejection, a petition, an open letter saying, you know, you can't have this person, you can't say that, you can't proceed. Now, sometimes that works and sometimes it doesn't. And I'm not going to go through those stories. I'm sure you know of some yourselves. But I do want to talk about the solution that the present Ontario government has proposed. I want to talk about why it's a good idea and why it probably won't work, at least not in the big sense of the problem. And to do that, I need to delve into the law of speech, the way it applies to universities, what university policies maybe should say, maybe what this directive from the government should have said to make it better. Okay, so that's where I'm going. Let's start at the beginning. At the beginning is the place where lawyers start in their heads with the first rule. The first rule of the legal system, the default position. So, just for a moment, imagine you're a lawyer. Now, I know it's kind of creepy, but bear with me. It won't take long. You're a lawyer, a client comes into you and says, here's what I want to say. Can I say it? And like most good lawyers, you tell the truth and say, I don't know. But I can find out for you. So let's say you go and you find out, and you look for the law as it applies to this problem. And just theoretically, this is probably not actually going to be the case, but theoretically, you go and look and you find nothing. You don't, no statutes, no common law, no policies, nothing. If that's not likely to be the case, but let's say that it is. If that is the case, if you find nothing, then the answer to the question is, we'll go right ahead. The default position is this. You can do anything you want, anywhere you want, anyhow you want, unless there's a rule that says you can't. In other words, when you go looking for stuff in the law, you're essentially looking for prohibitions and not permissions. If there's nothing there, you got a green light. All right, so the law of speech. What kind of rules are there? Now, we say we live in a country with free speech, and that's generally true. On the other hand, that is not an absolute statement, of course. There are things that limit speech, these kinds of things. Hate speech, harassment, discrimination, defamation, assault. Now, there's a right in the Charter to freedom of expression, guaranteed constitutionally. So how can it be that if the right is guaranteed, that there are these limitations? If I stand up on the sidewalk or in my classroom, and I say, you know, my colleagues, Bill and Jeff, they cheat on their taxes. Right? That's speech. But it's also defamation. And they can sue me for damages because free speech is not absolute. And the reason it's not absolute is that there are reasonable limits to the freedoms and rights expressed in the Charter. Okay, now next stage. Let's just clear this up. When we talk about speech at universities, we're talking about two related but different things. Now, free speech is essentially a term of art in the law. And what's being referred to when you use that term is the concept that's reflected in that charter guarantee. In other words, the right of free speech means that the government, the state, is not allowed to come and censor you in a way that is beyond a reasonable limit. It's a constitutional question. The academic freedom question is between faculty, essentially, and the university. So the first one is between the citizen and the state, and the second one between the professor and the university as an institution. Okay? Two different legal questions altogether. And in Canada, for the most part, the university is not considered to be part of the state. There are exceptions, but for the most part, that's the story. So, the Constitution, that charter guarantee, does not apply to the university question. So you can just cross it off the list. Doesn't matter. So what we have left is academic freedom, and then whatever other notion of free speech we want to talk about. But when we're talking about that, we're talking about the speech being limited by the institution and not by the state. So that takes us out of all of the law, all of the case law that deals with the question of free speech as considered constitutional. All right? Now, if we think about free speech on campus, let's start with this proposition, a very simple one. The laws about speech that exist in Ontario and in Canada apply to universities just like they apply everywhere else. Right? So if I stand up in my classroom again and defame my two colleagues, well, the law of defamation applies. And I cannot say, oh, well, I have academic freedom. I can say what I want in my classroom. That's not true. My right of academic freedom comes from the contract between the university and my union. And if I stand up and state my academic opinion about a subject, the university, in contractual terms, is not allowed to come and make me stop. But that deal in the contract has nothing whatever to do about the application of all those other laws to your classroom, to the talk, to the faculty boardroom, to any spot in the university. The university couldn't make those laws not apply. Can't be done. It's part of the country, therefore the country's laws apply. Now, why would a university limit speech? I'd like to suggest to you there is no reason to do it. None at all. Those laws apply to universities. Why would you need extra limitations on speech? Here's the proposition. Here's what we're saying. That there should be more restrictions on speech, more restrictions on academic speech. And by academic speech, I mean academic theories, opinions, studies based upon data or analysis that you might speak in a paper or in a classroom or in a talk. The proposition is that there should be more limitations on that academic speech than there is in a conversation on a sidewalk. And those people who favor university control of speech will give you various reasons why that should be so. One of them is that the university has a responsibility to govern speech in its spaces. If you're talking legally, that is not true. There is absolutely no rationale, no requirement, no call in the statutes or in the common law that exist out there, in the law in general, that universities should be controlling their speech. Here are the kinds of statutes that people refer to as providing a rationale for why universities should do this job. And again, my answer is the same. If you look at what's actually in them, that's simply not true. Just so, for example, you will often hear people say, well, we can't have someone come in and use hate speech in giving a talk. Well, sure. If they come in and they utter hate speech, then that's a crime. And if that were to actually happen, the proper response is to call the police, because that's how the law works. But the chances of it actually happening are next to nil, because the threshold we're talking about, this is section 319 of the Criminal Code. It goes like this, 319.2. Everyone who, by communicating statements other than in private conversation, willfully promotes hatred against any identifiable group is guilty of an offense. Now, the threshold that's being imagined in this section, as the courts have confirmed, is an extremely high one. You are trying to willfully promote hatred with an effect. If you were to come in and teach a class or give a talk on your theory that, for example, men are men and women are women, that could not possibly constitute hate speech. Okay? So most of the time, when you hear people say, oh, well, that's hate speech, it means they have no idea what they're talking about. Okay? That's not what hate speech means. Hate speech is a very specific, very high threshold matter, one they do not have in the US because their constitutional guarantee protects them from that kind of limitation. Nevertheless, we have it, it's constitutional, but in the normal course of academic life, it has no relevance whatsoever. Human Rights Code. Now, I'll come back to this one a little bit later, because it may be starting to become a problem, but it was conceived and intended similarly to not possibly apply in a classroom or a talk setting. But I'll come back to that later because it's starting to grow into a problem potentially. Occupational Health and Safety Act. Some people say universities have a responsibility to govern their workplaces, to prevent things like workplace harassment. That may be so. It may not be inappropriate for a university to have a policy on workplace harassment in the same way that any other employer might. Okay? That's a different thing than governing the content of academic speech. That kind of policy should have no application to when you walk into your classroom and do your thing. Common law, defamation, and so on. All right, so what am I getting at? Here's the thing. Going back to that first principle. If there's nothing there, you can do what you want. So ideally, universities should have no policies about the content of speech, because that means you can say what you want, except as the law restrains you. That's a situation that should exist. The law applies, don't break the law. If you don't break the law, say what you like. There is no reason to have any other kind of rule. So why do we have this? This is the Doug Ford directive. As you may know, it requires universities to develop and submit a policy upholding free speech by January 1st of this year, and the policies are now in. And the content of those policies are to mirror the content of the statement at the University of Chicago, which is considered to be the gold standard. It's supposed to be places for open discussion and free inquiry, should not attempt to shield students from offensive ideas, and you're free to criticize and contest views. All this is good. All this is very good. And I am glad to have this. I think it's better to have it than not have it, for sure. But it's a bit of a strange thing, right? Because the ideal situation is that we don't have any policies about free speech. And the reason that we need these, is that we had other ones before. Policies that said, oh, by the way, we want safe spaces, so you can't say that. So what we're really doing is they're trying to substitute better policies for worse policies. So that's okay as far as it goes. But there are some problems. The first problem is that you're asking, this directive is asking the university to put together its own policy to express what it means to do. In other words, you're giving the university the opportunity to weasel out of what it was you're demanding of them. There was no need to do that. You're the government. You could have simply gone to it yourself directly and said, here's the new rule. The new rule is you're prohibited from restricting free speech, period. The law applies, yes, but other than that, don't worry about it. In fact, we're prohibiting you from worrying about it. But they didn't do that. I don't know why, perhaps for political reasons, perhaps it was too heavy a hammer, I don't know, but that's not what we have. What we have is a process now, and that process has involved universities going and having committees and drafting this policy, all of which are in, and many of which are now problematic. I've just taken one for example. This is the policy from Lakehead, which they've now submitted to the Higher Education Quality Council of Ontario. If you read it through, at first glance, it might seem to be pretty much okay. While all forms of expression should be undertaken in a manner that also recognizes the free expression rights of others. Okay, good, great. Lakehead may properly restrict expression, for example, that violates the law. Okay, well, the law applies. Is threatening, harassing, or defamatory? Well, I listed defamation and harassment as two real laws that do apply. Discriminatory or invades privacy or confidential interest or compromises health and safety. What's the problem? Let's look at the problems. First problem is this. Lakehead, the university, is taking upon itself the job to restrict expression. If you have laws, then you already have bodies to do that. If, for example, somebody utters hate speech, then call the cops. If I defame my colleagues with their taxes, then they should hire a lawyer and sue me. In every respect, when a law is breached, there's a place to go to have the law enforced. The universities do not have to do this themselves. They should not be doing this themselves, because what you're getting are little university kangaroo courts who have no idea what they're doing and making stuff up and applying law that's not the law. And note this. Lakehead may properly restrict expression, for example, that violates the law. Stop. That violates the law. That's all you need to say. Stop. Because if you list more stuff, now you're suggesting that there's more than that to restrict. You're violating the law, and if it's threatening, that's no good either. And if it's harassing, which means that maybe you mean a different thing by harassing than the law means by harassment. Same thing with defamatory, same thing with discriminatory. Suddenly you get your own category of things, and nobody knows what they mean. And whenever the universities go down the path of trying to explain in their policy, what harassment means or what the law means, they always get it wrong. Always. So nobody knows what the rule is, which may be the way they want it. And finally, here I want to bring your attention to this, which is the worst part of all. Okay? So they've said Lakehead will restrict, the law is fine, here's all the extra things, but also speech that compromises health and safety, well, can't have that either. Now, what the hell does that mean? That gives them an open-ended discretion to decide when your speech is unsafe. And that brings us right back to the beginning. That's the whole reason we had the directive in the first place. So here we have an example of a policy that complies, sort of, with the directive that doesn't really change anything. Right? So I know progress takes place in little steps, but this is a really little step. Here's what the policies should say. Speech on this campus is subject to the law. That's all. Period. Of course, that's not what is required, so that's not what they say. But if you're actually imagining the proper policy, that's what it would be. Now, you might also say that there's another category of rules. I think that's fair enough. So that's the first thing. This is the version of the policy that deals with content. And there's another piece, too, I think, to a policy, and that is dealing with time and place restrictions. So if you imagine you're in a classroom, you're teaching a class, you're having a discussion, and student 1 has said something, and student 2 has said something, and student 3 has said something, and you're carrying on, and then student 1 starts to yell and won't shut up. He's had his say, but he won't settle for that. He starts to disrupt the classroom. And he says, free speech. Well, you have to be able to insist that he sits down and shuts up, not because of the content of his speech, but because he's now speaking in a way that's disrupting everybody else's ability to carry on. Okay? That's what I mean by time and place rules. It's okay for a university to have a rule that you can't put posters on the windows. They're not restricting the content, they're just saying that's not the right place for a poster. The danger with time and place rules is that sometimes they pretend to be time and place rules, they're masquerading as that, and their real effect is to govern content. So for example, if there are security fees involved in booking your room, that's really just a time and place thing. We want you to have you here. You have to pay this fee. It's fine. We're not governing your content, but actually you are, because you're preventing the speaker coming in to speak because somebody else has said, well, we don't like it. Okay, so that's the danger in this category of policy rules. Enforceability. So it's a different category of problem with this directive. Let's go back to the law. If you imagine the defamation case, I insult my 2 colleagues. They hire a lawyer and sue me. It's a civil action. Plaintiff, defendant, goes to court. If someone utters real hate speech, really hate speech that reaches that high threshold of 319, you call the cops. Again, that's unlikely to happen in the university context, but let's say that it does. Well, that will go to a criminal court. It's now the queen, the prosecution, and the accused. If you have tenure and the university fires you without cause, well, that's going to be a legal dispute. But that legal dispute is between the parties to the contract. And the parties to the contract are the union and the university, not you. You cannot sue the university for firing you. Your union can. And your union, that means you're dependent upon them for responding properly. But my point is that dispute is a kind of dispute, and that will probably go to an arbitrator, because that's what the contract says. In each kind of dispute, there are both parties and there's enforcement in some kind of adjudicative tribunal. Except when this directive is breached. When this directive is breached, what happens? None, not really. I mean, you can make a complaint. Here's what you're supposed to do. You're supposed to complain first to the internal bodies in the university. And then if you want to, you can complain to the Ombudsman of Ontario. And the directive provides that the universities are to report to the Higher Education Quality Council yearly on how they're doing in complying with this directive. And if they're not doing a good job, if they're breaching the directive, then it's contemplated that their funding might be cut. Okay? But here's what's not possible. If you bring in a guest speaker, for example, and the university says, no, sorry, can't have that person, you are not now empowered to say, look, I had a right to bring the person in, and I want to complain now about the right. I want to essentially sue you for breaching your obligations and protecting free speech. It can't be done, because there is no right. There's the saying, the legal saying, it's sort of the legal version of the proof of the pudding is in the eating. You can't claim to have a right unless there's some place to go to get a remedy. And if there is no such place to get a remedy, then you ain't got no right. And this is a situation in which there is no right. Okay? So we have a process. We have a political process that encourages universities to do a certain thing, and they're sort of doing it. They've submitted their policies, and they're sort of okay, but mostly not, and they'll apply them as they like, and there will be some problems, and those problems will either show up or not in their reports, and then the Higher Education Council will assess how much they're in the wrong, and there might eventually sometime be some kind of consequence in terms of their funding, but probably not. That's the scenario we have. That's the new tool. Again, better to have it than without, but I mean, it's really not that great. So here's just what I was saying. Here are all the places where legal disputes end up: courts and tribunals and arbitrators, internal, and so on. And unlike, well, the first three are actually adjudicators that adjudicate conflicts between parties with interests. And the others are not. And those are the categories that we're in with this policy. Here are some responses to the directive. This is one of my favorites. This is James Turk, who you may be familiar with, former head of the CAUT. He's not the only one who has said this, but he said basically, look, this directive for free speech undermines free speech because it prevents universities from deciding how to restrict free speech. I mean, it's also been suggested that the directive prohibits protest, which is crazy. That's not true at all. It protects protest. What it prohibits is the protest preventing the talking. You can do whatever you can say whatever you want, but you can't prevent other people from doing the same thing. It's a reciprocal kind of liberty, as it should be. That's all. They just don't like the idea that all the lefty students won't be able to shut down speakers they don't like. That's the problem. And equally crazy is this kind of suggestion from Okufa, that people will be scared to talk about it because their free speech is being protected. It really does reflect, I think, what McClatchy said in her Globe and Mail piece. So the bottom line, I think, is this. We're better off with the directive than without it, but it alone will not change the climate away from that. And a lot of the people who are in the universities, control the universities, will insist that that is still their mandate. because that's what they believe. And the directive is not powerful enough to push them off that path. Now, of course, there are a whole lot of other much bigger problems at the university, much more substantial problems that, let's put it this way, in a way, this free speech thing happens at the margins. Yes, when you bring in a speaker, they want to say something, people don't like it. It looks to be a central thing. And it is a central thing in terms of a symptom. It is a symptom of the way the university now works. But to attack that event is to miss the point. There are a whole lot of other things that are much more entrenched. The things that control your lives. You know, peer review. Criteria for tenure and promotion. The control over hiring. Who gets hired? Mark was referring to the criteria for how you make an application now for a job. I mean, none of that will change. We're not talking about that at all. How you get your pieces into publications, into journals. I mean, peer review, yes, but there's also other kinds of control that make sure that the kind of articles they don't want don't get in there, regardless of their quality. This is not about quality. Let me just give you an example, and then we'll chat. Here's a statement from, and I don't know how it is in your disciplines, but in our disciplines, many of the academic law journals have student editors. This is one of the student editors at one of the law journals. She says this: I think this is a really good time for law journal editors, meaning the students, to have a discussion about how we handle publication of professors who have been accused of sexual harassment. Have been accused of sexual harassment. Not convicted, accused of. She says, a neat thing about the structure of student-run journals is that we, as students, have the power to shape legal and academic conversation. We choose the topic. We choose who to invite to the table. We choose whose voices we hold up as valuable. We owe it to academia to think about what choices like this mean. What does it mean to people watching how seriously we take harassment? What does it mean to the students who file complaints against this professor about how we value them and their contributions? Here's the message. We're not going to evaluate the paper. We're going to evaluate the person. And if we don't like who the person is, they don't get in, because we control the publication. And those publications are your route to tenure. And this is not even the university. And it's not even your colleagues. These are the students. They are new gatekeepers. Okay, so it's just a taste, as you know, of all the underlying, deeply embedded problems in the institution. And with this directive, we're just really scratching the surface. Again, I don't want to reject it. I'm glad to have it, but it's really not a big deal. Shall we talk?
Yeah. Thank you.
Thanks for the talk. My biggest concern about what you said there is when you say, but hate speech falls under the law and we don't need to worry about the threshold super high. I think that hypothetically, if this was successful and there was free speech on campuses, that the intellectuals, the people that want to restrict speech, will quickly move to the law. Like we already see definitions of words changing on things like in major dictionaries and things like that. And I understand the law is separate from dictionary definitions, but I strongly believe that who defines hate speech is going to be huge. Because something like white privilege theory, you could say falls under hate speech if you argue that hate speech is sort of subjecting a group to a specific stereotype or that sort of thing. Mm-hmm. So my concern is that this group, and I've never come to this before, and I'm just a guest of Mr. Leonard, but I think that this group should be focused on the law and thinking about, because to me, the First Amendment in the United States is having the First Amendment causing the issues that the states might have, but like, do we need restrictions other than, let's say, advocating genocide? Like, do we need restrictions other than beyond that? Because who defines what discrimination is? Who defines what hate speech is? 100 years from now could be very different than what the group in this thinks of those words.
You make a very good point. So let me clarify my observation about the hate speech. So, in my opinion, that section of the criminal code should not exist. I mean, I do not think that's a proper law to have. I think you should be able to say what you like. Now, the dividing line is between saying what you think and advocating violence, right? So if you go and say, look, I want you to go with a torch and burn that guy's house down, okay? That's a crime. But if you stand back and say, well, I don't like such and such group because in history, yada, 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 yada. Fine, no problem. Yes, there is a danger. But I'd like to suggest that the danger, first and foremost, is not in the hate speech provision. Because, I mean, as poorly as our courts are performing recently, there's a body that's performing much, much worse, and that is the Human Rights Commissions and Tribunals, right? So,
What is that? Why do we have that?
I wish I had an answer for you. We should not have it. But here's just two examples. Yes, you may be familiar with the first one. Here we go. Here's the Ontario Human Rights Commission. So we have a human rights code, and that code makes no reference to speech. The word speech is not in the code, but it prohibits discrimination. And the Ontario Human Rights Commission, who is given the job of developing policy based upon the code, has said, in its opinion, that because there is the provision against discrimination, including gender identity, that if you don't use the proper pronoun, that constitutes discrimination. Yeah, that's their opinion, and technically speaking, it's not the law, but in all practical respects it is. Okay? That's Ontario. Another example. Here's the BC Human Rights Tribunal in a case just recently, not at a university, but occurred during an election campaign. And one of the candidates was a woman and transformed to a man, or vice versa. I can't forget which. Anyway, there was a person who essentially campaigned against this person.
Bill Whatcott.
That's right. Exactly. Bill Whatcott. And basically just I mean, he has some views that are not mainstream, but he's entitled to them. Exactly. And he did a very energetic job of campaigning against this woman with leaflets and so on. And the tribunal said this. They said, doing that is discrimination. And they went further. I think this is the most interesting part of the whole decision. They said this. They said, if you have a transgender person, you can argue that they should be elected because they're transgendered. But if you say they should not be elected because they're transgendered, that's discrimination. You can't say that. Okay? We're now at a situation where the idea of the equal application of the law is out. That view is being pushed by the Human Rights Commissions and Tribunals.
We got to move on. At Dalhousie University, the Students' Association said that the Atheist Society could argue in favor of atheism, but not against religion.
Right.
I have Rachel, Andrew, Phil, and Janice on the list, and we'll see how we're doing after that. Please keep your questions short.
I'm here from the University of Chicago. Bruce, what was interesting about the example that you gave of the provision, right? It's interesting how they reworded it. If you have the example,
the Lakehead example.
Yes. So I obviously know Jeff Stone, who is one of the primary authors of the statement, and he is a lawyer, a constitutional lawyer, First Amendment lawyer, right? And I've actually talked with him personally about some of the things that have been being said about me. And lawyers have very high bars, right? It's like you're right when I describe to him what people have been saying about me, and whether my friends are all telling me, oh, it's libel, you should sue, and I tell Jeff, and he's like, you'll never win.
Right. Exactly.
One,
yes.
because you'd have to prove damages, and you're clearly too cheerful, right?
Right.
Stay cheerful, but you'll never win damages that way. And so I think that, as you say, the laws bar is super duper high.
Yeah.
What the problem is the conversation is happening at the level of feelings, of
Yep.
civility,
Yep.
and of sort of people expecting to be able to shut each other up on that level. And so what's interesting about that provision, one, what Jeff's language actually was the university may restrict expressions that violates the law, that falsely defames a specific individual, that constitutes a genuine threat or harassment, which they left out, that unjustifiably invades substantial privacy or confidentiality interests, or that is otherwise directly incompatible with the functioning of the university. In addition, the university may reasonably regulate the time, place, and manner of expression to ensure that it does not disrupt the ordinary activities of the university. But these are narrow exceptions to the general principle of freedom of expression, and is vitally important that these exceptions never be used in a manner that is inconsistent with the university's commitment to a completely free and open discussion of ideas.
Right.
And what you're demonstrating with that one is how the very careful, and
Yeah,
Jeff
but
thinks
that-
he's
but-
being careful, right?
But see, that's no good either, the one you wrote up.
Well, because it follows on this other thing about concerns about civility and mutual respect can never be used as a justification for closing off discussion of ideas.
Right, but
That's
yeah.
what they think is going to fly. And of course, you're right.
Yeah.
Even laying it out like this is going to create a
But
problem.
so the version that you read
Yeah.
has more qualifiers, right?
Exactly.
Right. But every time you include another qualifier, you give the university another word to interpret, so they can decide what's reasonable. If you mean, you got to mean what you say, and or genuine or whatever the qualifier was, right? So the qualifiers don't protect you. So.
I know. We got to move on to Andrew. Andrew.
Thanks, Bruce. So one of the first slides you had put up was about the state, the constitutional versus contractual, and
That
I'm
one.
wondering on that with universities in Ontario, for example, being public institutions,
Yeah.
why they do not fall into that category of the state. And the flip side, with the Trinity Western University decision, why private institutions don't have the protection of the contractual.
Yes, excellent question. So you might think, as in the States, my understanding is that in the States, the state universities, the public universities, are considered parts of the state, and they're subject to constitutional limitations. There have been a mixture of cases on this question, and there are some situations in which universities are held to be part of the state, but it depends upon the degree to which the government is directing them to behave in a certain way. So they're exceptional instead of standard. The standard view is that they're not. I think because they have independent boards of governors and they have the independence to decide their own course. Now, that is also problematic because the government, as you can see with this directive, has the ability to tell them what to do. So it's a funny gray area, and that's the way it's come down right now. I don't agree with it, but there you have it. The Trinity Western thing is a whole big mess in itself. It's a private university. It tried to open a law school. It has a community covenant requiring students and faculty to sign on to certain obligations. The Law Societies of BC and Ontario didn't like the covenant and said, well, we're not allowing your graduates to practice. They used, to make a long story short, they used the charter guarantee of freedom of religion. Well, they overran the freedom of religion on the grounds that they were acting unequally. Which, I mean, we can go into it, but it makes no sense at all. They're using the charter against a private institution, and the charter is not being allowed to be applied against the public institution. It makes no sense at all. It's one of the Supreme Court of Canada's worst moments, I think, ever.
Phil. Oh, here, Phil, take the microphone.
I want to point to a deeper underlying problem that, in my experience as an engineer at the University of Toronto from 1965 onward, we've been developing a kind of ignorant bureaucracy that has controlling a lot of what we do. I've run into it on the misuse of teaching evaluations, more particularly. There was we had a code about where we had to show reportability or accountability on certain issues. I made the mistake of saying that I wouldn't sign the document because I hadn't read the reports and I didn't need to.
Right.
It was impressed on me that I really should lie in order to satisfy the bureaucracy further up in the system.
Now, are you speaking primarily of inside the university or outside the university?
Inside the university.
Inside, yes.
There's bureaucracy of
Right.
ignorant people that are
Absolutely.
now trying to run around our university.
Sure, yeah. So my observation there, my experience has been, now, of course, when you're talking about administrators, there are exceptions to the general rule, for sure. We have a principal right now at Queen's, just finishing his term, who, in a series of free speech controversies that I was involved with some guests that I brought in over the past year or so, including Jordan Peterson, that evoked all kinds of nasty reactions from faculty and students, the principal said, no. We are in the business of open, engaged debate. So, this is going to happen. So more power to him. But as a general rule, my experience has been that administrators are interested in the path of least resistance. They just want to stay out of trouble. And whatever path leads them to that, they'll do. And so if they can get you to sign the form without reading it, because that completes the pile and they can send it off to whoever they need, that's what they'll do. There's no principles involved. It's just a matter of process and getting rid of problems. So I totally agree with you.
Janice.
I'll try to keep this short because I have so much to say about it, but I wanted partly to, and first I want to apologize because I'm sure you're sick and tired of people who know nothing about the law talking to you about the law as if they know something about it. So I apologize in advance, and I wanted to second what the young fellow at the other end of the room said about law and the definition of hate speech, because I was very interested a number of years ago. It's a 2013 Supreme Court decision about Bill Watcott, that same fellow. This was an earlier incident in which he had left leaflets on cars talking about what he saw as the introduction of approval of homosexual practices in the primary school system. He did speak crudely about homosexuality. He talked about it as filth, that sort of thing. He didn't name any particular individuals, but he said it was wrong. He was taken to, I think, by the Saskatchewan Human Rights Commission, fined for hate speech. All of this went all the way to the Supreme Court. And they have a long decision about, have you read it? Because it's horrifying. They can't themselves define what hate speech is. They say at one point that even if the speech is true, that doesn't prevent it necessarily from being hate speech. They talk about how free speech doesn't apply because hate speech is not the sort of speech that promotes free speech. So therefore, that's all I wanted to say.
Well, so Janice, can we make this observation? Do you think this is fair? So, with the university, we have a chicken and egg problem, in the sense that the universities are now sort of doing what the culture seems to be demanding of it, and yet the culture is that way because the universities have helped the culture be that way. And the law, after all, is really only just a cultural system of authority, right? So if you want to change the law, the law is not a book of stuff you go and you say, well, that's the law, so you can't do that. No. If you want to change the law or influence the law, you got to change the culture. And we're losing the culture war, and the universities are a good reason why we are. So, chicken and egg. Do you fix the universities first? Is that possible to do? I think it's probably not. You have to have the culture demand that the universities change, but then you need a culture that will demand that change, and we don't have that culture right now. So I don't know where you start.
We have Stephen and Bill, and I think that would be time. Stephen and Bill, Etienne and Guillaume, those are my children's names.
Maybe you have can speculate on this, but one of the things that we keep looking to in this culture is the safety that the courts can provide us.
Right.
And we already know that the
You should
human
stop
rights
doing that,
tribunals
yeah.
have gone down the toilet.
Yeah.
Now, you're not surprised, of course, because you're a law professor. You're not surprised that law schools are poisoned probably as bad or worse than many disciplines.
Yeah, right.
Not as bad as sociology, probably more poison than my discipline. what is the public going to think when it becomes completely clear that the courts no longer respect things like the reasonable person test, or intentionality, or motivation? What happens when it becomes known that the law schools are just as tied up in identity politics as the sociology departments? And how can we rely, as you, in some of your videos, how can we rely on Madam Justice being blind?
You can't. You cannot rely on them at all. I mean, this is the thing. The bottom is falling out, and people don't realize it. And I can't answer your question. I don't know what the public will think. I don't know. I mean, of course, the public is a very differentiated, all kinds of different people in the public, and they bring all different kinds of levels of knowledge to this kind of question. But there are enough signs already. There have been enough cases from the Supreme Court, for example, to demonstrate what you're saying. The TWU, the Trinity Western case, I think is the best example of a case that you got to see. If you read it, you think, what are you talking about? I mean, it makes no sense unless you have an agenda. And I would say, on the basis of that case, the court has an agenda. And that's exactly the kind of thing that the court shall not have. The court, if you have a Supreme Court with an agenda, you've got a cultural problem that dwarfs all the other ones. So I don't know. I don't know what happens. I have no idea.
Bill.
Again, thanks for a terrific talk. Even if we had a perfect law as you've described, wouldn't the existence of the human rights tribunals still represent an instrument for the absolute interdiction of disliked speech and an instrument in the hands, the publicly funded hands of a complainant who says, look, you gave a lecture on the fact that X, and I perceive that to be discriminatory, and you're going to spend the rest of your life and $50,000, and you're going to end up losing.
Yes. Yes. Short answer is yes.
That's very reassuring. Thank you.
So just some context for the human rights process. So it's not a court, it's a tribunal, which means it's part of the executive branch of government. There are two bodies, the commission and the tribunal. And the commission is both an investigative body and a policy body. And the tribunal is an adjudicative body. They hear the complaints. And the commission, because it's both policy and investigative, has a point of view. It wants certain things to be wrong. And it can investigate things with that in mind. If you're a complainant, you can go and complain for free. And the commission takes over. And they have lawyers, and they'll do the investigation if they are persuaded it's a good cause. And if you're the defendant, you have to hire your own lawyer and defend yourself, even if there's nothing in it. And then if you win, you don't get your costs paid. You pay your own lawyer. So the whole thing is set up to be complainant friendly, regardless of the actual substance of the matter. So yes, in order to actually make any real progress in this area, you've got to get rid of the whole thing.
Good. We'll reconvene at 5 after 11. Thank you, Bruce.